Welcome to this week's edition of It is Chaile Time. I'm doing the last case law review for the year. And before we get to the detail of what we're talking about today, over the last, let's say, 5 to 6 years, I've been doing case law reviews on the Labour Court, Labour Appeal Court, and the occasional CCMA Arbitration Award. And, in terms of my journey that I've walked with case law reviews, I started to do it 5, 6 years ago on text. I always wrote a bit of a summary on Word, and I will also then put that out on social media and also do text on LinkedIn and so forth. And then this last year, 2023, I did it on Chaile Time, like today. I am evolving a little bit further, the concept that is, and from 2024, I will no longer do Chaile Time or case law review on It's Chaile Time. But what I'm doing is I'm starting like a VIP conferencing, I don't want to use the word club, but okay, it's out there. Let's call it like Toby's VIP club, okay, or case law review club, if you can put it this way, on Zoom. So I'm going to do it live. It will probably just be like 15 minutes, but one day a month. And invites go out to our general emailer. Now we've got probably 500-600 people on managers and HR managers and professionals on that emailer, whereby people will then be notified on which day every month we will do a little 15-minute get together and just to go through the case, go through a certain case study. Why do we do this? I know it sounds maybe boring, but it's really not, and it's extremely important. The reason is that the law, in this case labor legislation, keeps on being developed by the court. So if you're an HR manager or somebody in that field, a labor relations manager, employee relations manager, or so forth, it's one thing to have your studies behind you. It's one thing to think you know the law, but the law gets evolved through the courts every day. So the labor law you know today is not the same labor law really, and I'm talking about the interpretation and the application of that labor law. It's not the same one you had a month ago. Just as a quick example, quickly how these cases get evolved. Like a week or two ago, we discussed maternity leave. Up to now, only women giving natural birth are entitled to maternity leave. There are other forms of leave available for different types of parents, like if you're a surrogate parent or adoptive parent, there's parental leave and adoption leave available. But now the High Court 2-3 weeks ago stated no, but any form of parent is entitled to maternity leave. And they actually declared that the provisions in the Basic Conditions of Employment Act dealing with maternity leave unfairly discriminating against a lot of types of parents. So this is exciting. So this is why we do case law reviews. So if you want to be included in our general emailer, to be invited, it's obviously free of charge. I mean, it's really just us going through the cases and, educating the HR community from this perspective. Let us know, send us an email, and then we can just include you on this general emailer. It is not a marketing tool. We send once a week content out, really to enrich you. We send It's Chaile Time. As we send Chaile Time on our social media platforms, we also send it on the general emailer. But we don't spam. We send it out once a week, and then once a month we will just notify people saying, listen, the Zoom conference for a case law, and give the title, will be on such and such day. And the intention is not to go longer than 15, maybe 20 minutes. Anyway, so okay, today, what are we dealing with today? We are talking about a sensitive topic, retirement age. Section 5 of the Employment Equity Act basically states that you cannot unfairly discriminate against people, and one of those classes of people are people in terms of their age, or people that have reached, let's say, retirement age. You cannot discriminate against people because of their disability, religion, faith, sex, gender, all these kind of things, but also not in their age. But now the question is, what about dismissals? Dismissing somebody for reaching age. Isn't it a bit of a contradiction here? Because on the one hand, labor laws say you can't discriminate against people based on, inter alia, their age. But then you see almost on a daily basis, companies in South Africa put people on retirement because of their age. Doesn't make sense. As a matter of fact, Section 187 of the Labor Relations Act goes a step further. It deals with automatic unfair dismissals. Now, just quick side note here. The most common form of dismissal is just a normal plain dismissal relating to either misconduct or performance or capacity. And if you go to the CCMA or the bargaining council will have jurisdiction to conciliate and arbitrate a dispute like that. And compensation, if a dismissal was found to be procedurally or substantively unfair, maximum compensation is 12 months. But automatic unfair dismissals are those kind of dismissals that are based on discrimination. The reason thereof is discrimination. Now, what you need to know is just, and this is a bit more sideline information, is that the CCMA Bargaining Council don't typically have the jurisdiction to arbitrate, even though you still start off with, at the CCMA or the Bargaining Council, with conciliation. But thereafter it must go to the Labour Court, such a case. And compensation is a maximum of 24 months. But automatic unfair dismissals, in terms of Section 186 of the Labour Relations Act, deals with dismissals that are based on discriminatory grounds. And in this context, what we're doing here, let's just read quickly. Subsection 1, a dismissal is automatically unfair if the employer, in dismissing the employee, acts contrary to Section 5, that's of the Employment Equity Act, or if the reason for the dismissal is, and then it lists a whole list of reasons for this type of dismissal, but I want to focus on F, that the employer unfairly discriminated against an employee directly or indirectly on any arbitrary ground, including but not limited to two, and then it names a whole list of direct grounds that a company can discriminate on you, and one of them happens to be age. Okay, so here's a bit of a problem now. You cannot discriminate against a person against his age. It can even be an automatic unfair dismissal if you dismiss somebody because of their age. Now, where does retirement fit in? Section 187, which we just read, also say in subsection 2b, B for Benny, despite subsection 1, which dealt with the unfairness of the dismissal, basically saying now a dismissal based on age is fair if the employee has reached the normal or agreed retirement age for persons employed in that capacity. So there are two qualifying elements here, the normal retirement age or the agreed retirement age. So typically what you will find in a contract of employment, there's a clause in there that says that you will go on retirement at age 60 as an example. Now, just interesting, there's no retirement age in labor laws. Interesting, eh? There's no such thing. There's a retirement age, I think it's 55 or something like that, in the pensions or the Provident Funds Act, but that's not labor legislation. That doesn't govern the employment relationship, really. So there's no retirement age in labor laws. That retirement age must be established by the company, either in terms of some kind of policy or practice or in the contract of employment. So obviously if it's in the contract, it will then constitute the agreed retirement age. But what if it's not in the contract? One will then typically look at what is the normal retirement age in that business. So we will look at the policy or the practice or the norm. It becomes a bit more difficult for the employer because how do you argue that this is the practice if nobody knows about it? Okay. Yeah, so it's obviously important that a company communicate that message. But now, the element that we want to focus on today in a labor appeal court case where the applicant was the Motor Industry Staff Association and Willem Frederik Landman versus Great South Panel Beaters. Now, this is a case that came out in 2022, September 22, I believe it is. So it is very recent. But the issue here is, it's going to open up this case, the issue here is, what if in the contract of employment there's an agreed retirement age? In this case, the agreed retirement age was 60. Mr. Landman was employed in 2008 and he so happened to reach the age of 60 in March 2018. But the contract states when you reach the age of 60, you will go on retirement. But now, what happens when the employer don't actually put you in retirement when you reach age 60? They actually only did that the next year in February 2019. So the argument here now goes, okay, the contracts say 60. But the employer don't retrench you at age 60. They waited like another, I think like 9 months or so. The applicant's argument in this case now, because the employer breached in a way the contractual agreement, there now consists a tacit employment relationship by virtue of this relationship continuing behind the powers of that provision itself. Now, this case went through the Labour Court, it came to the Labour Appeal Court now, and I also believe because, the Labour Appeal Court and the Labour Court sided in favour of the employer party, the case is now also going to the Constitutional Court. So in a way, we are wide-eyed, we're waiting to see what's going to happen from that case. But the Labour Court basically referred to the following case law, Schweitzer versus Waku Distributors. In short, the principle established in Schweitzer is that a dismissal based on age is not automatically unfair in circumstances where the employee has indeed reached the normal or agreed retirement age. So if you reach a retirement age, it is not an automatic unfair dismissal if that is the reason for your dismissal, provided that is obviously the normal or agreed retirement age in the company itself. The Labour Appeal Court had to then address this, also went further and addressed this whole issue about the tacit employment relationship. And I think where matters sometimes get confusing, especially for people practicing in labour law or so forth. Sometimes the messages of the legislator can be quite confusing because there's a similar kind of event or incident where the converse is actually true. And here I'm talking about fixed term contracts of employment. In terms of section 186 subsection 1, if an employer created a reasonable expectation to renew a fixed term contract and they don't do so, that actually constitutes a dismissal. And one of the elements of this is when an employer don't terminate the employment contract, a fixed term contract. Let's say this fixed term contract expires today as an example. But today the employer don't tell me goodbye, your contract expired, and he'll allow you to continue working, let's say for the next month or 2 or 3 or whatever the case may be. The way this concept then evolved for our courts is that that person actually then are deemed to be an indefinite, or the more commonly used word is a permanent employee, by the fact of there's a tacit employment relationship, created because the employer didn't terminate your service based on the termination date of the fixed term contract. So now I suppose people want to use the same concept and draw it into this argument, but okay, there's a clause in the contract saying you retire at age 60. The employer didn't do so. So now, 9 months later, they can't now depend on that clause and say, listen, here's a golden handshake, nice pen, maybe a bit of a bonus, go, you're done. The Labour Appeal Court also then alluded and actually made people, or in this case now, the parties aware of section 187, subsection 2b. Now, just thinking about this now, is that in the argument with the fixed term contract, there's nothing in the LRA that actually deals with, timelines. There's nothing really per se that say specifically, there's no provision that say, if you let somebody work beyond the termination date of, or the expiry date of a fixed term contract, therefore he is now a permanent employee, okay? There's only now section 188B that deals with marginalized employees, inter alia employees earning below the earnings threshold, in terms of subsection 5, that if that fixed term contract longer than 3 months is not justified in terms of subsection 4 with all the justifications, then that person is deemed to be an indefinite employee. But there's no specific provision in the LRA that say specifically, if you work beyond your expiry date of fixed term contract, you are now therefore permanent. But here's legislation, section 187, subsection 2b. I've just read it, that basically say that it's not an unfair dismissal if you reach your normal retirement age. But there's no timeline on here. So this is what the Labour Appeal Court is saying. There's no time lock on it. There's nothing that says that, a person must be going on retirement by no later than a month after reaching retirement age. It just say in general that it is not unfair dismissal or automatic unfair dismissal if you are dismissed for reaching the normal or agreed retirement age period. So are we now trying to read into it that, it means that you must be dismissed on that same day you wake up on your birthday when you are 60, now you must be dismissed? I think the court's view is we're taking that argument too far. One thing I know about our legislators are that, they don't like technicalities. So, disputes must be resolved with the least amount of legal technicalities and formalities. We try to speedily resolve disputes. So the Labour Appeal Court is basically saying, listen, I think we're trying to read too much into this. The fact of the matter is the dismissal relates to retirement. Whether it was on the day or 9 months later, in their view, this is irrelevant. Now, obviously, there are those people who will not agree or may agree, but this matter, I believe, is going to the Constitutional Court. So, yeah, bit of a contentious issue, and that is all for this week for It's Chaile Time. And this is also now the last Chaile Time for this year, 2023. We will continue on the 8th of January, 2024. So we obviously want to wish you all the best for this year, for the Christmas season, and enjoy yourself if you're on holiday. If you are working, enjoy yourself too. Don't drink and drive. What's going on here?
Jingle bells.
Oh my goodness, look who came to visit. You here?
Yes, your head.
Oh, flip, I must take this hat off. Whee,
Ho, ho, ho.
Are you for the Christmas now? Where's my present?
It will pop up soon. It will pop up soon. How are you?
I'm well. It's the year end. People are planning to go on leave. It's that time of the year.
Yeah.
Yeah, it's December already. Huh? And yourself?
I'm good. I'm good. What's the review of your year? How did your year look?
2023. Yeah, see, there's so much that happened, Seppo. I mean, Effectus Harmony is ever expanding, employing more people. I'm a kind of person, I love employing people. That doesn't mean South Africa you must apply now. Okay, I'm just saying I love employing people. It's very nice. Okay, it brings me personal satisfaction. We have more people joining us in January, which is nice, and hopefully by the end of next year there will even be more. We're building more offices. That's nice. I think there was exciting things this year. One of the great successes is Chaile Time. Yeah. We are focusing a lot on education. We have started Effectus Harmony Education, so we are next year going to focus a lot on training programs. We've got the one out already on how to correctly issue a written warning in terms of the common law of fairness. And we have Chaile Time, which is our media arm to the world out there in South Africa, which is, in my view, quite exciting. I think we did well. All we do, Tsepo, is to take South Africa with us on our weekly journey, how we meet companies, meeting staff, and just relate what we see and what we feel, what we experience. Sometimes as an HR manager, you wonder, how does it happen or work in that company? Yeah. Well, now you know. We tell it all, but we don't name and shame. We don't say who we are, and we are quite clever. Sometimes when a she does it, we say he, you see. So if I talk about your company and I say she, don't think it's your female boss. No, it may be the other guy, you see. And when we say something happened in Pretoria, it actually happened in Cape Town. Yeah. So don't try to figure out.
Who are we talking about?
Yeah, so that's Chaile Time. I think from our IR work this year, I think we've been very successful. That was really exciting. And also we got our charity on board, the Tshwane Child Welfare. Yeah. We didn't just live ourselves, so that was exciting. But also yourself, Tsepo, I must just say thank you for this year. Also for you, I really, really appreciate you. And
thank you very much. I appreciate
you've grown so much now. It's fucking unbelievable. I remember when you started 2 years ago. Look, we've been together 15 odd years, and you've been involved in IR for many years. But you officially started here, I think 2 years ago or so. And I know how nervous you were, and that first big cases, I thought, maybe I must hold your hand, and I'm just like, I don't have time for this, you must just swim. And Tsepo, you did it. And I remember, yes, a big case, you did at the Roadfront Industries Bargaining Council, an unfair dismissal case based on an illegal strike. Oh man, those people were eating out of your hands. You faced 2 union staff. Eventually, after a year, the bargaining council threw the case out because of lack of jurisdiction. Yeah, so it's good memories. I think we had good memories the last couple of months.
And actually, time flies, because you do a case today, you sleep at night, your mind doesn't stop working on that case. You wake up the next morning, you give out the outcome of that case. Then boom, there's another case. Then you have to prepare for counsel. Then you have to drive to Vryburg for 5 hours. And then you sit there for 15 minutes. Like 2 weeks back, I drove to Rustenburg. Same thing happened. Pulled the jurisdiction card. Yeah, that's a card that
We've learned this year. Jurisdiction. Jurisdiction.
Yeah, so it's been quite an experience. But I really appreciate you, putting trust in me and then letting me be me and do my thing. Magic. Most of our sister brother company clients love me.
Oh, they love you. This man speaks 7 languages. I'm telling you. Amazing.
So every time when I walk in at a different place and then I speak the language and then they start, flirting with me in the business sense and then, and then they will be like, but we only want Tsepo to come here. We don't want anyone else. We want Tsepo to come here. But yeah, it's been quite an experience. Good year, I can say.
Yeah, I think it's a good year. I'm looking forward to next year. And but anyway, our message for now, Christmas, don't drink and drive and behave yourself. And yeah, if you're an employee, remember to fill in your leave form and to actually get your boss's signature. Don't assume you're on leave. Nah? Don't do your own thing.
Yeah, because you don't want the Tsepo to rock up in January and say, because people say we hate them. I don't like the thing of, but people hate
hearing that people will say that my boss don't like me.
Yes.
But when I remember when I managed in corporate, staff will come to me crying. My supervisor was rude. He swore at me or whatever. You know what I always do? Okay, let's just park your supervisor for a moment. Let's talk about you. What did you do? No, I came late from lunch. Okay, what was the result? The customers swear at the supervisor. So I'm like,
yes.
Do you still want to complain about your supervisor? Let's talk about you, man. What did you do?
That's actually what I was saying. So yeah, but enjoy the rest of the year.
Anyway, Tsepo, jingle bells all the way and have a nice Christmas
and then prosperous
see you next year.
New Year. Bye.
Awesome. Bye-bye.